Hello class, this is Dr. Branch. I trust you're having a good day. We're going to discuss Christian ethics and the legal history of abortion. For those of you who are taking me for ethics or for introduction to ethics, whether at the graduate or undergraduate level, there are 4 cases which you need to know for the final exam. Those 4 cases are Griswold versus Connecticut, Roe v. Wade, Doe v. Bolton, and Planned Parenthood versus Casey. So I have several cases in here. Those are the 4 you'll need to know for the final. So let me just point out a little bit of the confusion about abortion that's out there in our culture. This is the song Red Ragtop by Tim McGraw, in which he talks about a young couple that has an abortion, and yet Tim McGraw was himself the result of a crisis pregnancy when his mother became pregnant by then minor league pitcher Tug McGraw down in Jacksonville, Florida. So this just shows a lot of the confusion that's in our culture on the matter. So let me scoot past several of these cases and information, and I'm going to take you directly to Griswold v. Connecticut. Griswold v. Connecticut was not a case about abortion. I often have students somehow say that on exams, and you're just wrong. The case was not about abortion. The case was in fact about contraception. And there was a law in the state of Connecticut which said it was illegal to use or to sell contraceptives. So the Planned Parenthood of Connecticut, under the leadership of Estelle Griswold, opened a clinic in Connecticut, and I'm being a bit metaphorical here, but they basically hung out a sign, a large neon sign, if you will, metaphorically, and said, "We're selling contraceptives here. Will someone please prosecute us so we can take this thing to court, so we can take the law to court?" Well, indeed, that happened. The state of Connecticut prosecuted them. They were found guilty, which is what they wanted, so they could appeal it in the federal courts. It worked itself all the way to the United States Supreme Court. And in this case, what happened was the court decided that the Connecticut law was unconstitutional and said that the law was illegal, and the reason the law was illegal was the right to privacy. Now, here's what you need to know. The phrase right to privacy never occurs in the United States Constitution. This is the first time, and at this point about 180 years of the history of the United States Constitution, that any court had found such a right. And so about 180 years after the Constitution is written, this court discovers a right to privacy. Now, the case was only about contraception, and it declared this Connecticut law illegal because it violated specifically a married couple's right to privacy, is what they said. But once this idea of a right to privacy is introduced in 1965, this concept becomes the judicial precedent for Roe v. Wade, which was about abortion. So remember, Griswold was about contraception. Griswold introduced the concept of right to privacy into American jurisprudence. Now, several years later, the laws in several states are changing. This is during the middle of the sexual revolution. Prior to the 1960s, all states outlawed abortion except for cases where the mother's life was in imminent danger. But several states had repealed their abortion laws altogether. There's a great deal of change, sea change in ethics taking place in our country during the sexual revolution. And so it's no consequence that as you have this widespread promiscuity, that eventually people want to deal with unintended pregnancies. One always leads to the other. So it's no coincidence that Roe v. Wade comes close on the heels of the end of the sexual revolution. That said, 1973, Roe v. Wade gives you legalized abortion. And the case revolved a young lady, Norma McCorby. She was the Jane Roe, that was a pseudonym. She was unmarried, pregnant, living in Texas, and she had given up her first 2 children to adoption. She tried to get an abortion for the 3rd child, could not. In fact, the child was born and adopted by another family, and apparently is alive somewhere in the United States today. But she was used by pro-abortion lawyers to test the Texas law outlawing abortion. Texas had a law that made abortion illegal, except in certain very rare cases. So, winds its way through the court system. I say she now claims she passed away in 2017, but she claimed to be born again Roman Catholic and pro-life and advocated strongly for the repeal of Roe v. Wade later in her life in an interesting turn of events. Now, the lawyers, just to point out a few things to you, Sarah Regal Weddington, one of the lawyers arguing for the overturn of the Texas law, was actually the daughter of a Methodist minister, and Linda Coffey, who was a member of Travis Avenue Baptist Church in Fort Worth at the time and was a Southern Baptist at the time. Disheartening. So the case, in a 7-2 decision, laws outlawing abortion, proscribing abortion, are declared illegal based on a right to privacy. Now remember, this idea of a right to privacy was introduced into American jurisprudence in 1965 to cover the right of a married couple to purchase contraceptives. It's now extended to abortion. If you tell me on the exam that the case of Griswold versus Connecticut was about abortion, I'm going to deduct lots of points. It was not about abortion. That case was only about contraception. But the principle of right to privacy is expanded in 1973, 8 years later, to embrace abortion. And basically, Roe v. Wade divides abortion up into 3 trimesters, and that said during the first 2 trimesters, states could not make any restrictions on abortion laws whatsoever. Then during the 3rd trimester, it said that some regulations could be enacted to limit abortion except for the health of the mother concerns, except for cases where there was health of the mother concerns. So what you need to know is that Roe v. Wade had an evil twin sister, and that was called Doe v. Bolton, which we'll talk about in just a second. But here's what you need to know. Roe v. Wade made abortion legal, all 50 states, United States, based on a right to privacy. Now, there are several problems with Roe v. Wade. The decision was written by Justice Blackmun, and Justice Blackmun makes several mistakes in the decision. But I'm going to talk to you about just a couple of them very specifically. At one point in Roe v. Wade, Justice Blackmun had the temerity to say, well, Greek and Roman law afforded little protection to the unborn. Notice, he appeals to pre-Christian pagan practices to justify the legalization of abortion. So he jumps over several centuries of Judeo-Christian jurisprudence and medical practice to appeal to pre-Christian paganism to justify abortion. Here's what I would remind you. There were lots of things the Greeks and Romans did of which we do not approve. For example, the Romans approved the practice of slavery and gladiatorial combat, and certainly we don't want those legalized in our country today. Now, I want to show you what I consider the major error in Roe v. Wade. This is equivocation. Equivocation is a logical fallacy that occurs when someone changes the meaning of a term without telling the reader that you're changing the meaning of the term. That's a very simple definition of equivocation. Now notice this quote. This is a long quote. This is the pivotal point of argumentation in Roe v. Wade. And notice what Blackmun says. He says, Texas urges that apart from the 14th Amendment, life begins at conception and is pregnant throughout pregnancy, and that therefore the state has a compelling interest in protecting that life from and after conception. Notice that in this sentence, Blackmun is clearly using the word life in reference to biological life. He's talking about beginning at conception. Well, biological life clearly begins at conception. Then he says in his next sentence, we need not resolve the difficult question of when life begins. Aha, he's equivocating here. I'll show you. Here he uses the word life as biological life, but here he's referring to this debated issue of personhood, which he goes through great discussion about in Roe v. Wade. Here's what he says. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus about when life begins, he says, the judiciary at this point in the development of man's knowledge is not in a position to speculate as to the answer. Notice when he uses the word life here, he's backed into this whole discussion of personhood. That's what he has in mind. Here he means biological life. Here he means a debated definition of personhood. Let me be clear. This is manipulative and this is deceptive. And it's evil when a Supreme Court justice does this at the pivotal point of his argumentation. So note clearly that he equivocates in the meaning of the word life. Also, I'd point out to you, and several people have over the years, there are numerous similarities between both the Roe v. Wade decision and the Dred Scott decision of 1857, which legalized slavery. And the parallel thinking there is really quite interesting. So let me move on to Doe v. Bolton. Here's what you need to know. Doe v. Bolton was decided on the same day as Roe, and you need to think of Doe v. Bolton as Roe's evil twin sister. There were two cases that day, not just one. Roe v. Wade and Doe v. Bolton, two cases addressing abortion, both decided on that day in 1973, and they are evil twin sisters. And here's what happens. In Doe v. Bolton, decided the same day, mother's health was defined in the broadest possible context to include anything such as finances and psychological health and mental health and all these other things, emotional, familial, the woman's age. And what happens is Doe v. Bolton clarifies and expands Roe. Taken together, Doe v. Bolton and Roe v. Wade are evil twin sisters which give you abortion on demand throughout 9 months of pregnancy in the United States. So let me scoot on to the last case, which is Planned Parenthood versus Casey. This is the last one I want you to know for the final exam. So the Roe v. Wade and Doe v. Bolton decisions, highly motivated pro-life people in the United States. They elected two pro-life presidents, Ronald Reagan and the first George Bush, who were appointing justices to the Supreme Court in hopes that Roe would be overturned. That was the entire game plan. So the decision, it revolved around Planned Parenthood versus Casey, revolved around a law in Pennsylvania. It's Planned Parenthood of Southeast Pennsylvania. A law in Pennsylvania which said a child could not get an abortion without parental consent, and that a wife could not get an abortion without her husband's consent, and also that someone had to wait 24 hours after they requested an abortion to get an abortion. So the Supreme Court took this opportunity to revisit the entire Roe v. Wade decision. And here's what they decided. That by a 5-4 decision, the core holding of Roe was sustained. Roe v. Wade was almost overturned. Justice Kennedy was a swing vote. We now know he was originally going to vote to overturn Roe, but then he changed his mind. He voted to sustain Roe, and he's gone on to be one of the most liberal justices we've known. Abortion rights were shifted, however. Roe v. Wade was a very poorly argued case, and here's your talking point for the final. Abortion rights were shifted from a supposed right to privacy, which is partially grounded in the 14th Amendment, to the more explicit liberty interest of the 14th Amendment. So here's what they also said, that some restrictions on abortion access were allowed. They said that if states want to, they can allow, or they can say things like a teenager cannot get an abortion without her mother's consent. They also said states can enact waiting periods before abortion. However, they overturned the part where a wife has to get the husband's abortion. So what that means is each individual state can craft abortion laws that allow some of these restrictions regarding abortion based on the political moral climate in those states. Therefore, laws in California are far more liberal than those here in Missouri or in Kansas. I have had students try to say that the Supreme Court mandated waiting periods for all 50 states. That's incorrect. You'll lose points if you say that. The Supreme Court only allowed states to put in these waiting periods if they so desire. So that's why abortion laws differ around the United States. They are more conservative in places like Missouri and Kansas than they are in some place like New York or California. So let me just bring, the last thing I would say is there is a very radical notion of autonomy enacted in Casey, and here's what it says. This is one of the most bizarre statements I've ever read, much less coming from the Supreme Court, written by a panel of 3 judges who wrote the majority decision. They say, these matters, abortion, involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy. There's the key word for Casey. It's all about autonomy. are central to the liberty protected by the 14th Amendment. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. My word, that's broad. Beliefs about these matters could not define the attributes of personhood were they formed under the compulsion of the state. This is absolutely meaningless jargon. I have no idea. It's the most nebulous phrase. What it means, though, is they are opening up a whole new radical notion of moral autonomy. And without getting into a lot of details, it is this notion of autonomy which led to the Supreme Court overturning all these laws defining a marriage as one man and one woman. It is a very radical notion. If you write a statement like that on your paper, I would deduct tons of points. It's meaningless dribble. So, let me say just a word about the Southern Baptist. Well, let me scoot through this quickly first. On your exam, here's what you need to tell me. The Griswold v. Connecticut, this gave us right to privacy. This case was not about abortion, it was about contraception. Roe v. Wade, abortion must be legal based on a right to privacy. Its evil twin sister, Doe v. Bolton, clarifies and expands Roe, and mother's health is defined in the broadest possible context. And then in Planned Parenthood versus Casey, the core holding of Roe is sustained, but abortion rights are shifted from a supposed right to privacy to this expansive and broad liberty interest of the 14th Amendment, radical moral autonomy. So let me give you just a little background. In 1971, when liberals were running the Southern Baptist Convention, the Southern Baptist Convention passed a pro-abortion resolution at the meeting in St. Louis. And here's what it said. Be it further resolved that we call upon Southern Baptists to work for the legalization that will allow for the possibility of abortion under such conditions as rape, incest, clear evidence of severe fetal deformity, and carefully ascertained evidence of the likelihood of damage to the emotional, mental, and physical health of the mother. This is a pro-abortion statement that sounds a lot like Doe v. Bolton. So the SBC is now rabidly pro-life. Our Baptist Faith and Message 2000 says that we believe in the sanctity of human life from conception to natural death, and I affirm that wholeheartedly. But here's the sad thing. In Christianity Today, the issue immediately following Roe v. Wade in 1973, the editors of Christianity Today interviewed some pastors, one of whom was our own beloved Dr. Criswell of First Baptist Dallas, Texas. When asked about abortion, here's what he said. I have always felt it was only after a child was born and had life separate from the mother that it became an individual person, and it has always, therefore, seemed to me that what is best for the mother and for the future should be allowed. This is disheartening that a man who stood so strongly for the inerrancy of Scripture and the truth of Scripture could be so misguided on an issue as crucial as abortion. But in some ways, Dr. Criswell was a child of his times, and he was reflecting some of the common thinking that people were saying about abortion. I'm giving you this quote to remind all of us that we need to think clearly about moral issues and make sure we are clearly standing on the Bible and not just on popular consensus on a number of things. So those are some notes about abortion. I hope this has been helpful to you and will help prepare you for the final exam.